A trademark, or trademark is a recognizable sign, design, or expression which identifies products or services of a particular source from those of others. Although trademarks used to identify services are usually called service marks, the trademark owner can be an individual, business organization, or any legal entity. A trademark may be located on a package, a label, a voucher, or on the product itself. For the sake of corporate identity, trademarks are also being displayed on company buildings. Usage. A trademark identifies the brand owner of a particular product or service. Trademarks can be licensed to others. For example, Bullyland obtained a license to produce Smurf figurines. The Lego Group purchased a license from Lucasfilm in order to be allowed to launch Lego Star Wars. TT Toys. Toys is a manufacturer of licensed ride-on replica cars for children. The unauthorized usage of trademarks by producing and trading counterfeit consumer goods is known as brand piracy. The owner of a trademark may pursue legal action against trademark infringement. Most countries require formal registration of a trademark as a precondition for pursuing this type of action. The United States, Canada and other countries also recognize common law trademark rights, which means action can be taken to protect an unregistered trademark if it is in use. Still, common law trademarks offer the holder in general less legal protection than registered trademarks. A trademark may be designated by the following symbols. Trademark sign. Registered sign. A trademark is typically a name, word, phrase, logo, symbol, design, image, or a combination of these elements. There is also a range of non-conventional trademarks comprising marks which do not fall into these standard categories, such as those based on color, smell, or sound. A trademark cannot be offensive. The term trademark is also used informally to refer to any distinguishing attribute by which an individual is readily identified, such as the well-known characteristics of celebrities. When a trademark is used in relation to services rather than products, it may sometimes be called a service mark, particularly in the United States. Fundamental concepts. The essential function of a trademark is to exclusively identify the commercial source or origin of products or services. So a trademark, properly called, indicates source or serves as a badge of origin. In other words, trademarks serve to identify a particular business as the source of goods or services. The use of a trademark in this way is known as trademark use. Certain exclusive rights attach to a registered mark. It should be noted that trademark rights generally arise out of the use of or to maintain exclusive rights over that sign in relation to certain products or services, assuming there are no other trademark objections. Different goods and services have been classified by the International Classification of Goods and Services into 45 trademark classes. The idea behind this system is to specify and limit the extension of the intellectual property right by determining which goods or services are covered by the mark, and to unify classification systems around the world. History. In trademark treatises it is usually reported that blacksmiths who made swords in the Roman Empire are thought of as being the first users of trademarks. Other notable trademarks that have been used for a long time include Lowenbrau, which claims use of its lion mark since 1383. The first trademark legislation was passed by the Parliament of England under the reign of King Henry III in 1266. Which required all bakers to use a distinctive mark for the bread they sold. The first modern trademark laws emerged in the late 19th century. In France, the first comprehensive trademark system in the world was passed into law in 1857 with the Manufacture and Goods Mark Act. In Britain, the 1862 Merchandise Marks Act made it a criminal offence to imitate another's trademark, with intent to defraud or to enable another to defraud. In 1875 the Trademarks Registration Act was passed, which allowed formal registration of trademarks at a UK Patent Office for the first time. Registration was considered to comprise prima facie evidence of ownership of a trademark, and registration of marks began on 1 January 1876. The 1875 Act defined a registrable trademark as a device, or mark, or name of an individual or firm printed in some particular and distinctive manner, or a written signature or copy of a written signature of an individual or firm, or a distinctive label or ticket. In the United States, Congress first attempted to establish a federal trademark regime in 1870. This statute purported to be an exercise of Congress' copyright clause powers. However, the Supreme Court struck down the 1870 statute in the trademark cases later on in the decade. In 1881, Congress passed a new Trademark Act, this time pursuant to its Commerce Clause powers. Congress revised the Trademark Act in 1905. The Lanham Act of 1946 updated the law and has served, with several amendments, as the primary federal law on trademarks. The Trademarks Act of 1938 in the United Kingdom set up the first registration system based on the intent to use principle. The Act also established an application publishing procedure and expanded the rights of the trademark holder to include the barring of trademark use, even in cases where confusion remained unlikely. This act served as a model for similar legislation elsewhere. Oldest registered trademarks. The oldest registered trademark has various different claimants, enumerated below. United Kingdom, 1876. The Base Breweries label incorporating its triangle logo for ale was the first trademark to be registered under the Trademark Registration Act 1875. United States. A design mark with an eagle and a ribbon and the words "economical," "brilliant," was the first registered trademark, filed by the Averell Chemical Paint Company on August 30, 1870 under the Trademark Act of 1870. However, in the trademark cases 100 U.S. 82, the U.S. Supreme Court held the 1870 Act to be unconstitutional. The oldest U.S. registered trademark still in use is Trademark Reg. Number 11210, a depiction of the biblical figure Samson wrestling a lion, registered in the United States on May 27, 1884 by the J.P. Tolman Company, a rope-making company. United States. In 1923, the businessman and author Edgar Rice Burroughs registered his fictitious character Tarzan as a trademark, even after the copyright to the Tarzan story expired. His company used ownership of the trademarks relating to the character to control the production of media using its imagery and license the character for use in other works. This practice is a precursor to the modern concept of a media franchise. Germany. 1875. The Krupp Steel Company registered 3 seamless train wheel tires, which are put on top of each other, as its label in 1875, under the German Trademark Protection Law of 1874. The seamless train wheel tire did not break, unlike iron tires with seams, and was patented by Krupp in Prussia in 1853. Symbols. The 2 symbols associated with U.S. trademarks, trademark sign and registered sign, represent the status of a mark and accordingly its level of protection. While trademark sign can be used with any common law usage of a mark, registered sign may only be used by the owner of a mark following registration with the relevant national authority, such as the U.S. Patent and Trademark Office. The proper manner to display either symbol is immediately following the mark in superscript style. Terminology. Terms such as mark, brand, and logo are sometimes used interchangeably with trademark. Trademark, however, also includes any device, brand, label, name, signature, word, letter, numerical, shape of goods, packaging, color or combination of colors, smell, sound, movement or any combination thereof which is capable of distinguishing goods and services of one business from those of others. It must be capable of graphical representation and must be applied to goods or services for which it is registered. Specialized types of trademark include certification marks, collective trademarks and defensive trademarks. A trademark which is popularly used to describe a product or service is sometimes known as a genericized trademark, if such a mark becomes synonymous with that product or service to the extent that the trademark owner can no longer enforce its proprietary rights. The mark becomes generic. A trademark look is an informal term for a characteristic look for a performer or character of some sort. It is usually not legally trademark protected and the term is not used in the trademark law. Registration. The law considers a trademark to be a form of property. Proprietary rights in relation to a trademark may be established through actual use in the marketplace, or through registration of the mark with the trademarks office of a particular jurisdiction. In some jurisdictions, trademark rights can be established through either or both means. Certain jurisdictions generally do not recognize trademarks rights arising through use. If trademark owners do not hold registrations for their marks in such jurisdictions, the extent to which they will be able to enforce their rights through trademark infringement proceedings will therefore be limited. In cases of dispute, this disparity of rights is often referred to as first to file, as opposed to first to use. Other countries such as Germany offer a limited amount of common law rights for unregistered marks where to gain protection. The goods or services must occupy a highly significant position in the marketplace, where this could be 40% or more market share for sales in the particular class of goods or services. In the United States, the registration process includes several steps. First, the trademark owner files an application to register the trademark. About 3 months after it is filed, the application is reviewed by an examining attorney at the U.S. Patent and Trademark Office. The examining attorney checks for compliance with the rules of the Trademark Manual of Examination Procedure. This review includes procedural matters such as making sure the applicant's goods or services are identified properly. It also includes more substantive matters such as making sure the applicant's mark is not merely descriptive or likely to cause confusion with her pre-existing applied for or registered mark. If the application runs afoul of any requirement, the examining attorney will issue an office action requiring the applicant to address certain issues or refusals prior to registration of the mark. If the examining attorney approves the application, it will be published for opposition. During this 30-day period, third parties who may be affected by the registration of the trademark may step forward to file an opposition proceeding to stop the registration of the mark. If an opposition proceeding is filed, it institutes a case before the Trademark Trial and Appeal Board to determine both the validity of the grounds for the opposition as well as the ability of the applicant to register the mark at issue. Finally, provided that no third party opposes the registration of the mark during the opposition period or the opposition is ultimately decided in the applicant's favor, the mark will be registered in due course. Outside of the United States, the registration process is substantially similar to that found in the U.S., save for one notable exception. In many countries, registration occurs prior to the opposition proceeding. In short, once an application is reviewed by an examiner and found to be entitled to registration, a registration certificate is issued subject to the mark being open to opposition for a period of typically 6 months from the date of registration. A registered trademark confers a bundle of exclusive rights upon the registered owner, including the right to exclusive use of the mark in relation to the products or services for which it is registered. The law in most jurisdictions also allows the owner of a registered trademark to prevent unauthorized use of the mark in relation to products or services which are identical or colorfully similar to the registered products or services. and in certain cases, prevent use in relation to entirely dissimilar products or services. The test is always whether a consumer of the goods or services will be confused as to the identity of the source or origin. An example may be a very large multinational brand such as Sony, where a non-electronic product such as a pair of sunglasses might be assumed to have come from Sony Corporation of Japan despite not being a class of goods that Sony has rights in. Once trademark rights are established in a particular jurisdiction, these rights are generally only enforceable in that jurisdiction, a quality which is sometimes known as territoriality. However, there is a range of international trademark laws and systems which facilitate the protection of trademarks in more than one jurisdiction. Search. In the United States, the USPTO maintains a database of registered trademarks. The database is open to the public. A licensed attorney may be required to interpret the search results. As trademarks are governed by federal law, state law, and common law, a thorough search as to the availability of a mark is very important. In the United States, obtaining a trademark searching relying upon the results of an opinion issued by an attorney may insulate a trademark user from being required to pay treble damages and attorney's fees in a trademark infringement case, as it demonstrates that the trademark user performed due diligence and was using the mark in good faith. The USPTO internally captures more information about trademarks than what they publicly disclose on their official search website, such as the complete contents of every logo trademark filing. Trademarks may also be searched on third-party databases such as LexisNexis, Dialog, and CompuMark. In Europe, and if a community trademark has to be filed, searches have to be conducted with the OHIM and with the various national offices. An alternative solution is to conduct a trademark search within private databases. Classification systems exist to help in searching for marks. One example is the International Classification of the Figurative Elements of Marks, better known as the Vienna Classification. Ability to register. In most systems, a trademark can be registered if it is able to distinguish the goods or services of a party, will not confuse consumers about the relationship between one party and another, and will not otherwise deceive consumers with respect to the qualities. Distinctive character. A trademark may be eligible for registration, or registrable, if it performs the essential trademark function, and has distinctive character. Registrability can be understood as a continuum, with inherently distinctive marks at one end, generic and descriptive marks with no distinctive character at the other end, and suggestive and arbitrary marks lying between these 2 points. Descriptive marks must acquire distinctiveness through secondary meaning. Consumers have come to recognize the mark as a source indicator to be protectable. Generic terms are used to refer to the product or service itself and cannot be used as trademarks.